Well, let's check what's on our legal docket. Hearsay evidence in Drew Peterson's upcoming murder trial. A motivational speaker who's been charged with 3 deaths at a sweat lodge. And then there's that teacher's insulting personal blog. Our legal guys are ready. Civil rights attorney Avery Friedman is in Cleveland, my hometown, and then New York criminal defense attorney Richard Herman in the very great city of Miami today. Well, let's start with the Drew Peterson case. In case you don't know, Drew Peterson's lawyers were in court this week for a key hearing. Peterson's a former police sergeant from Bolingbrook, Illinois, is accused of killing his 3rd wife and also being investigated in the disappearance of his 4th wife, that's Stacy Peterson. So at issue here is hearsay. Tell us about it, Avery. What exactly is hearsay?
Hearsay is information evidence that is not direct. In other words, it's coming from a third party. And as a general rule, and most people know this, that hearsay is generally not admissible. However, the rules of evidence provide for exceptions. And what was argued this week before a 3-judge panel, Marty, was whether or not third persons can testify in the murder trial involving Drew Peterson, and that is specifically evidence from the dead 3rd wife who told her sister something about Drew, and the missing 4th wife, that's Stacy, who told her minister about something. Bottom line, the court has to resolve the question of probative value, that is, will it help getting to the truth, against the prejudice, and that is, will the prejudice outweigh the probative value? The trial court said no. That's what the 3-judge panel has to resolve in the arguments this
Richard,
week.
I can see you shaking your head. Go ahead.
Well, basically, Mark, it's a statement made by someone other than the declarant. So Avery's right. What the prosecution is trying to do is put in evidence of statements that supposedly his 3rd wife made to other people and his missing wife made to other people. And they're going to try to tie that in to show some sort of intent to commit murder against his wife. Now, listen, the trial judge who heard the motions on this back in May ruled that the evidence was not reliable and therefore it is not going to be admissible. And he applied the law as it stood in the state of Illinois to that ruling. The prosecution had 30 days to appeal that decision, Marty. 30 days. It's simple. You must appeal it in 30 days. And they didn't.
Yeah, they missed
They
the
did not go to court. They didn't ask for an extension of time. They just blew the filing deadline. So before we get into the intricacies of the hearsay laws in Illinois, it's over and out.
All right,
they
well, I got to keep you guys on a schedule because I know how it goes. So let's get on to our sweat lodge case. Jury selection begins. This is Speaker James. He's a motivational speaker, James Arthur Ray, and he's charged with manslaughter in the death of 3 people in this sweat lodge. Now, let me ask you this. Richard, what is the prosecution's case here? What are they maintaining?
The prosecution maintains this guy's a lunatic. He put these people in a perilous situation in some sort of smokehouse there. They were pleading to be released from the place. He wouldn't let them out. He made them go back in there. He forced them in there, and 3 people died, Marty. I mean, it's ridiculous. Where's the common sense here? The defense here is the sweat lodge was built improperly. That's their defense. No jury's going to buy that. This guy's going to get hammered 12.5 per death, plus a flood of civil lawsuits against him.
All right, well, that seems pretty cut and dry. So let's go to the teacher's case, because this really is pretty fascinating. This is the Pennsylvania teacher. She has a personal blog. She writes some not so nice things about her students, and now she's been suspended. First of all, Avery, First Amendment, isn't it? I mean, how can she be suspended? What's going on?
Absolutely. Not only does it violate the First Amendment, Marty, but it also violates the 14th Amendment due process clause, because the school district had no policy when it came to internet use. The fact is that there was nothing inappropriate for this teacher in her words, in her blogs rather, about what she does. And the fact is that if school districts, government will punish teachers for their expression in a private blog, that essentially not only blows up the First Amendment, but it blows up the due process rights of every public school teacher in America.
Richard, you agree?
Yeah, no names, Marty, anonymous. No names of students, no name of school district. Wasn't uncovered till a year later. done maybe tongue-in-cheek, maybe not, I don't know. But Avery hit it on the head. There were no rules and regulations prohibiting this. So the First Amendment's going to protect her. It's going to be okay. They can't fire her for this
She's
one.
going to have a lot more to blog about, that's for certain. Richard Herman, Avery
for
Friedman.
sure.
We'll talk to the both of you a little later. Thanks very much.